Yes, Mr. Wheeler.
I was going to move on to the question of incremental development. The fund, of course, relies heavily in that regard on White and Jones.
Someone has got a microphone on that shouldn't be on and is causing a bit of feedback. Anyway, let's hope.
I hope it's not me, my lord.
It's you who's feeding back, but probably not through your microphone.
Yes. My lord, in addition to White and Jones, there are two other lines of authorities referred to by the Court of Appeal, which point strongly against any incremental extension of the law, because they are, in my submission, wholly inconsistent with the alleged duty arising on the basis of the facts that have been pleaded by the fund. Firstly, the authorities that address circumstances in which a party falls under a duty to protect someone against wrongdoing by a third party. And secondly, the decision in Royal Brunei Airlines and TAN. And I'm going to address those in turn. But given that incremental extension depends on drawing analogies between existing authorities and the current pleaded case, the starting point in my submission has to be the precise way that the duty is pleaded and set out. And perhaps I could invite you to turn back to page 61 of the bundle, where we see precisely how the claim has been pleaded. And paragraph 68 is, in my submission, key. In my submission, 68 really is the basis for the alleged duty. It arises, it's said there, from the bank knowing or having constructive knowledge of the fact that the monies in the client account were not beneficial, were not the property of Sion beneficially, but instead the master fund. In my submission, we do not need to look at any other part of the many particulars of claim to see the pleaded basis for the duty of care. Nothing else is advanced as a basis for that duty to arise beyond the first line and a half of paragraph 68.
Well, and 70.
And 70, although 70...
70 is a slightly broader expression
well,
of it.
70 is simply focusing on the difference between whether or not it's known that it was Sion that was the beneficial owner, and whether it was known that there was someone, whether it was known that the fund was the beneficial owner rather than Sion, is 68. 70 is whether someone other than Sion was the beneficial owner without specifying who. That is broader, but in my submission that if this claim is to succeed, given that we are at the moment assuming the pleaded facts to be true, and therefore we're assuming for these purposes the bank knew that Sion was not the beneficial owner and the fund was. 68 is key in my submission, and 70 provides an alternative fallback on the facts, but on the question of principle as to whether a duty of care is owed, there's no difference at all in my submission. It may be that if one could succeed on the specifics of 68 but fail on 70, but that would all just turn on the facts, which is not something I'm getting into for obvious reasons. But in my submission, for the purposes of this appeal, there's really no difference in principle between the two ways of putting it. My learned friend, of course, refers to 69. That, in my submission, simply goes on to identify the consequences of the alleged duty. In other words, what does the duty oblige the bank to do or not to do? And it's at that stage that the existence of the grounds for believing that the fund was being defrauded are referred to, and that is what triggers the obligation to refuse to honour instructions for payments out of the account until inquiries have been made and the propriety of the account's conduct has been established. Now, the way the case is put, the way it was put both this morning and the way it's put at paragraph 36 of my learned friend's written case, that's page 709 of the bundle, is slightly different, because there it's suggested that one can have paragraph 69 essentially constitutes a different duty to 68. 69, my learned friend says, is not simply the consequences of the duty pleaded in 68, but 69 is a separate duty. And that separate duty arises from the fact that there is notice of fraud. In my submission, that's not how the case is actually, it's not correct understanding of the pleading. It's my first point in response to that. My submission, the correct understanding of the pleading is to see the duty in 68. and the 69 is simply the consequences. And indeed, that's how it's reflected at paragraph 8 of the fund's written case on page 698 and in the agreed statement of facts, paragraph 18 at page 686. But it's not simply a pleading point. It doesn't work.
Well, no, I'm going to say, Ms. Wheeler, that there was a custom, at any rate, in the Chancery Division, that if you failed, if you were the claimant and you were likely to be struck out on your pleadings, but only essentially because you hadn't pleaded something that otherwise you could have pleaded on the facts, then you get a locus penitentiae to see if you can improve your pleading and save from being struck out.
My Lord, yes. But in my
so it would certainly help us, I think, if you could deal with it on the broader basis.
I'm going to, my Lord. And in my submission, the change doesn't help the appellants.
The paragraph 69 point.
Paragraph 69 point.
Yeah.
Firstly, because one still has to ask the question, where in 69 is there an assumption of responsibility? We have notice of fraud. But that, one can see, goes to foreseeability of the fund suffering loss. But there's nothing there that passes between the bank and the fund. Nothing that the bank does or says to anyone that could be said to constitute an assumption of responsibility. Secondly, the point does not work because taking care to look out for indicia of fraud is one of the things that the duty requires. It's not being said, and the way it's put in 69 is not to say that the bank knew that a fraud was taking place and allowed funds to be paid out. It's saying if circumstances were such that a reasonable banker would have had grounds for considering that there was a serious or real possibility of a fraud. In other words, if the bank ought to have suspected a fraud, is essentially what's being said, then certain action should have been taken. But putting it in those terms, necessarily in my submission, brings the point about notice of fraud as a matter of substance into what the duty that is alleged required the bank to do. The duty required the bank to be on the lookout for fraud, for signs of fraud, and if it became aware of signs of fraud, it was required to take action. So one cannot, in those circumstances in my submission, and then use the very thing that it said the bank was under a duty to do as the basis for the foundation of that duty. The duty has to exist before the obligation to be on the lookout for signs of fraud can arise.
You've qualified this by your introduction, and indeed, you said the wording of the pleading, that a reasonable banker would have had grounds for considering. But you said it might be different if the banker actually knew and was passive.
Well, I think the first answer to that, Madam Ward, is that's not the allegation.
No, but if it knew...
If it were the allegation, would you accept then there would be a duty of care?
Not knowledge by itself, my Lord, no, because one comes back to the same question. Where is there an assumption of responsibility? Of course there's a duty to the customer. That's we can take as read. So it's not, I'm not suggesting the situation in which the bank is on notice of a fraud and can just ignore it and carry on. The plain duty to the customer. But this, in my submission, none of this takes us beyond the contractual duty to the customer and extends that to a duty of care in tort to the fund. In order to do that, there has to be some link in my submission between the bank and the fund, some connection of some kind. And mere notice of the fraud, in my submission, is not enough for that.
One must be quite careful about one's choice of language, mustn't one? If a bank gives effect to an instruction knowing that the instruction forms part of the commission of a fraud, then it's hard to see how the bank would escape from a finding of dishonesty.
Well, that may be right, my lord.
And similarly, if the bank is reckless as to whether there's a fraud, it would probably be dishonest to comply with the instruction. But if only there were facts which would put a banker acting with due care on notice of a fraud, as you say, that begs the question as to whether there's a duty.
My lord, yes. I think when I answered my Lord Kitchen's question to say no, there would not be duty, I was focusing very much on a duty of care in tort. Of course, I accept that if one gets into the realm of dishonesty, the path to liability is obvious. One has dishonest assistance, and that's, as a matter of principle, perfectly clear. I'm not disputing that for one minute. But when one is below the level of dishonesty, which is what we're at here,
Yes.
there is in my submission nothing in what's pleaded in 69 that provides the requisite connection between the bank and the fund. That then takes me on to the question of the nature of the duty, because the fund in its written case contends that the duty was a duty on the bank not to undertake a positive act, in other words, the payments out of the account, and that by making payments out of the account, the bank itself caused harm to the fund. And in my submission, and as the Court of Appeal approached the claim, that is not correct. The pleaded duty in my submission on correct analysis is a duty to protect the fund from the risk of fraud. In other words, it's a duty to protect the fund from the consequences of third-party wrongdoing. And we can see that from the way the case is put. Paragraph 69 talks about notice that there's a risk, that the account is at risk of fraudulent misapplication. In those circumstances, the bank must make inquiries and refrain from paying out funds unless it's satisfied that the account is properly operated. If you move on to page 73, paragraph 106 is where breach of duty is pleaded. And the nature of the breach of duty that is alleged is a failure to take steps which ought to have been taken, and the fact that the bank permitted Siam to continue to operate the client accounts. So in other words, it's a broadly phrased allegation that the bank failed to intervene to prevent fraud when it was on inquiry of it.
Sorry, which page are you on? I'm sorry.
I'm sorry, my lord, that's page 73.
73.
Paragraph 106 of the...
Well, could you not read 106 as saying permitted Siam to continue to operate the client accounts, i.e. continue to accept Siam's instructions and act in accordance with the payment instructions received, i.e. in breach of a duty not to? I mean, maybe there's more here that makes your point good.
There is more, and I'm going to perhaps come back and answer that question indirectly, if I may, because I'm going to come on to some of the authorities to how one approaches the distinction between acts and omissions. And it's very easy, and this is the point that emerges, it's very easy in many cases to characterise a particular act of wrongdoing as an act rather than an omission, which is why the authorities move away from that distinction and focus on the nature of whether this is causing harm or whether it's protecting against wrongdoing or
this is the old
benefiting.
Failing to put the brakes on.
Yes,
Type of issue, yeah.
Lord, yes, and I'm going to come back to that in a moment, if I may. But I was also going to show you at page 81 the way loss is pleaded, the way causation and loss is pleaded. And there one sees, and I won't read it out, but the essence is, had the bank complied with the duty that was on it, the fraudulent payments out of the account would have been prevented, and the losses from the fraud would have been avoided. And the way that the damages that are claimed are pleaded at paragraph 120 is essentially the sums that were paid out over and above the point at which the payments out would have stopped had the bank complied with its duty. In other words, it's the additional losses from the fraud that it is alleged that the bank should have prevented.
Is that the limit of what's claimed? It's seeking to recoup the payments out of the account?
Lady, yes, I think that's right. It's the deficit. There's some attempt to take into account various expenses of receivership and so forth. But the essence of it is, it said if the bank had acted as it should have done, the fraud would have been stopped. And so therefore, a certain proportion of funds lost to fraud would not have been lost.
Well, in 118 it said that had the duty been complied with, then further payment instructions would have been declined pending receipt of instructions from the administrator and or the directors, and they would have investigated and caused. So it's a chain of causation, which they're alleging is, in the counterfactual, would have followed from refusal to comply with the instructions.
My Lord, yes, that's right. But the net effect of that is...
The net effect may well be...
The fraud would have been stopped.
Protection. Yes. But it's pleaded slightly more carefully than that, isn't it?
But does it matter what the pleading actually is? I mean, your point, as I understand it, is this is a case where you've got a third party who's directly caused the loss, and therefore the duty must, in some sense, be to stop that third party causing the loss.
My Lord, yes, that's the essence of it. That if one steps back and one asks why has there been a loss to the fund, the answer is because there was a fraud affected on the fund. The bank's not alleged to have been party to that fraud or involved in that fraud. So in that sense, the bank hasn't caused the loss from the fraud. The way in which it's alleged the bank caused the loss from the fraud is by not intervening and stopping the fraud from continuing and stopping the losses from continuing to accrue. And indeed, if one looks at the contractual duty by way of comparison, in Singularis, paragraph 23, it's at page 944. I don't think I need to ask you to go there, but Baroness Howell described the purpose of the quince care duty as being to protect a bank's customers from the harm caused by people for whom the customer is one way or another responsible. But the point is it's a duty to protect.
Well, it's the purpose is to protect, but the duty is very precisely defined in quince care. It's to refuse to honour instructions until a satisfactory explanation which dispels the suspicion about what those instructions are about has been received. Now, its purpose, no doubt, is to protect people from fraud, but it's not a duty to, as it were, get into your coat of armour and put up your anti-fraud flag and go around trying to stop a fraud.
Well, in substance, my Lord, it is where there is notice of fraud. And in substance, when one looks at the nature of the duty, what it said the bank ought to have done, and how that has caused loss, all of that is, in my submission, really is coming back to saying that the loss, what it is that the bank must guard the fund against, the harm that it must protect the bank from, is the loss caused by the fraudsters. That's the essence of it in my submission. It's not that the bank has done something and made a mistake in providing a service like we see in Golden Belt. The bank there did something positively wrong, which caused loss, for which it was liable. Here, the starting point is the fraud. The starting point has to be the fraud in my submission. And the bank's only involvement in affairs is not as party to the fraud, but as the entity which it is said should have curtailed the effects of the fraud.
Yes, I mean, in Singularis, it had gone certain stages further because the bank had made inquiries as to what the justification for the suspicious payments were, but the bank was at fault in accepting those explanations, which were clearly shams.
My lady, yes.
Yes.
And of course, had it done so, the losses would have stopped. I said I would move on to look at some of the authorities on this point. Perhaps I could invite you to turn to N in Paul, the judgment of Lord Reid, which is at page 1314.
Well, sorry, just help me before you go to it. What's the proposition you're going to derive from this authority?
The proposition is the nature of the relevant distinction is between causing harm and failing to confer a benefit, rather than between acts and omissions.
Yes.
And that when one looks at a factual scenario, and it's very difficult to determine if one simply tries to characterise as an act or an omission. Very difficult to determine which camp you fall into. The approach you take to that is to look at the nature of whether one is causing harm or failing to confer a benefit. And the relevant passage is at 1314, paragraph 28, where Lord Reid refers to the fact that public bodies, just like private individuals, do not generally owe a duty to confer benefits on individuals. He says, in this context, I am intentionally drawing a distinction between causing harm, making things worse, and failing to confer a benefit, not making things better, rather than the more traditional distinction between acts and omissions, partly because the former language better conveys the rationale of the distinction drawn in the authorities, and partly because the distinction between acts and omissions seems to be found difficult to apply. And he goes on at paragraph 31 to refer to Stovin and Wise, and there, at the start of 31, referring to the distinction between harming the claimant and failing to confer a benefit on him or her, typically by protecting him or her from harm. So protecting from harm very much falls into the failing to confer a benefit category. Then a little further down on page 1316, we have a quotation from the speech of Lord Hoffman in Gorringe and Calderdale Metropolitan Borough Council. At paragraph 33, the quote is, Lord Hoffman stressed that the House was not concerned with cases in which public authorities have actually done acts or entered into relationships or undertaken responsibilities which give rise to a common law duty of care. And my learned friend in his written submissions says, well, the bank has actually done something because the bank has given effect to the payment instructions on the account. But in my submission, one needs to see that quote in the context of the quote that comes in the previous paragraph, also from Gorringe. At the bottom of page 1315, picking up the last two lines from this quotation. Reasonable foreseeability of physical injury is the standard criterion for determining the duty of care owed by people who undertake an activity which carries a risk of injury to others, but it is insufficient to justify the imposition of liability upon someone who simply does nothing, who neither creates the risk nor undertakes to do anything to avert it. In my submission, that reference to someone who simply does nothing needs to be understood as distinguishing between someone who creates a risk or undertakes to do something to avert it. And when we see in 33 the quote about someone who has actually done something, that's not a reference in my submission back to the crude act-omission dichotomy that Lord Reid is suggesting we move away from. But it's a focus on the relevant act that gives rise to the harm which there is a duty to guard against. And in my submission, one sees a further illustration in that in Stoving and Wise, which is at page 1436, and one sees how that works in practice. The case concerned the failure of a local authority to take steps to improve the safety of a piece of highway in which an accident occurred. And the defendant was liable to the claimant for the accident, but then claimed contribution in respect of that liability from a local authority on the ground that the local authority was at least partly responsible for the accident because of a failure to take steps to improve the safety of the particular stretch of road. The authority denied that it owed any duty. Now, it's important to note that the council was not entirely inactive in this case. It hadn't simply done nothing, to use the term from Gorringe. It had decided that action needed to be taken, it formulated a scheme, and it simply needed the permission of the relevant landowner to put it into effect. And when the landowner didn't give its consent straight away, the matter went stale. And if I ask you to look at the top of page 1436, where Lord Hoffman quotes the judgment of Lord Justice Kennedy in the Court of Appeal in this case. And what Lord Justice Kennedy said was, here the Highway Authority did not simply fail to act, decided positively to proceed by seeking agreement from British Rail, and its failure to pursue that course is not an admission on which it can rely to escape liability. And that, in my submission, illustrates how readily one can find a path to characterising a particular instance of wrongdoing as involving an act rather than an omission. But Lord Hoffman, at the following paragraph, rejected that analogy. He said, of course, it's true that the conditions necessary to bring about an event always consist of a combination of acts and omissions. Mr. Stowing's accident was caused by the fact that Mrs. Wyve drove out into Station Road and omitted to keep a proper lookout. But this does not mean that the distinction between acts and omissions is meaningless or illogical. One must have regard to the purpose of the distinction as it is used in the law of negligence, which is to distinguish between regulating the way in which an activity may be conducted and imposing a duty to act upon a person who is not carrying out on any relevant activity. To hold the defendant liable for an act rather than an omission, it is therefore necessary to be able to say, according to common sense principles of causation, that the damage was caused by something which the defendant did. So, in that context, one turns to focus on the nature of the harm which the alleged duty on the bank relates. And the starting point for the need for the bank to act is the possibility that the fund is the victim of the fraud. In other words, it's the victim of third-party wrongdoing, not wrongdoing by the bank. And in my submission, the substance of the duty is a duty to protect against the consequences of that fraud. One can't say the bank made things worse by its positive act by virtue of the making of the payments. Those were only problematic because of the fraud. And that way of arguing the case, in my submission, just simply falls back on a dichotomy between acts and omissions. And it's often possible to frame matters as involving an act in some way or other. But the question is one that turns on the nature of the duty in my submission. And the reason why these payments shouldn't have been made is that it said it shouldn't have made the payments because the bank was on notice of fraud. And it's that notice of fraud that...
Well, not on notice of, but on suspicion of.
On suspicion of fraud, yes. Perhaps that's a better way of putting it, but on suspicion of fraud. But that triggered the obligation to step in and prevent that loss. In my submission, when one analyses it by reference to the questions of causation, taking Lord Hoffman's question of what on common sense principles of causation was the damage caused by, the damage in my submission was plainly caused by the fraud, first and foremost. And if that is right, one can simply look to the well-established circumstances in which there's a duty to protect a claimant from third-party wrongdoing. The general rule, of course, is that there is no such duty, but you can be liable if there's an assumption of responsibility. And the Court of Appeal, in my submission, rightly adopted that analysis and rightly held that there was no pleaded basis at all for an assumption of responsibility by the bank to the fund in respect of the risk of the loss to the fund from third-party fraud. Because, of course, one's asking an assumption of responsibility, one also has to ask the question, assumption of responsibility for what? And in my submission here, it's assumption of responsibility to protect the loss from fraud by others.
Have we got a clear statement? I mean, I think what you've been establishing is that the law's always been very nervous about duties of care in relation to omissions, and you've explained to us from N against Poole how the Supreme Court, Lord Reid, has now clarified what exactly that difference is, and that this, on that analysis, is a case of omission, i.e., one's needing to step in to prevent a third party's wrongdoing. Where do we find the statement as to what the principles then are as to when the court will impose a duty of care for these types of situations?
The best summary is perhaps Lord Torson's speech in Michael and Chief Constable of South Wales Police.
Thank you.
That's at page 1243, and the relevant passage is at paragraphs 97 to 100. I should also say I've referred to a number...
Is that where you get this threefold?
Milady, yes, it is. And I have also referred to a number of authorities in my written case. I can provide you the reference.
There's Poole as well, isn't there? Paragraph 60.
Yes, and in fact that, I'm afraid, that if you're relying on the hyperlink in my written case, it's an erroneous hyperlink, but the relevant page is 1324.
That's Lord Hoffman.
Yes.
No, that's Lord Reid.
Beg your pardon. That's
Sorry, Lord Reid,
yeah.
yes. And Lord, yes, also paragraph 19 of my written case, which is at page 750.
Thank you.
Yes, the reference there should be 1325.
Yes, I think, yeah, 1324, 1325, my Lord, yes. Yes, apologies, that hyperlink is slightly off. So, turning then to the question of whether there was an assumption of responsibility on the pleaded facts, the question is whether there was something which crosses the line between the parties, either by word or conduct, whether that be the bank performing a service for the fund or making some representation to it or something similar. And there is nothing in the particulars of claim at all that alleges any such crossing of the line. No statement by the bank to the fund is alleged, nor vice versa, no statement by the fund to the bank.
But Mr. Arthur, was it Turnstone?
Yes.
Who was Turnstone acting on behalf of?
Turnstone was the administrator of Siam. So Turnstone was effectively Siam's agent.
And all the agents have their own agents?
Lady, yes. And there's of course, a corporate director, which was Peacock as well. So
the concept of crossing the line is a familiar one in all sorts of areas. Where would you say is the best authority that an assumption of responsibility requires some crossing of the line?
Lord, that's Williams and Natural Life.
Yeah.
And the Lord Stane speech, and the relevant passages at 1496. Letters F to G.
Thank you.
So there was no statement, there was no undertaking by the bank to provide a service to the fund, nor did the bank in fact provide a service to the fund. No dealings between the bank and the fund at all from which it could be said to be understood that the bank was undertaking to protect the fund from fraud. All the bank did is operate the account for Siam. By its nature, the operation of that account was a service provided to Siam as account holder rather than to the fund. The mere fact that Siam happens to owe duties to the fund as a third party doesn't, in my submission, change that at all. There is also, importantly in this context, no allegation that the fund relied on the bank in any way, nor did it in any way regard the bank as being responsible for protecting its position. The Court of Appeal, in my submission, was right not to infer reliance, as the fund says it should have done, in the absence either of a pleading of reliance or some evidence that reliance was placed by the fund on the bank. And indeed, my submission, the way in which the scheme was set up and the way in which Scion was effectively interposed between the fund and the bank demonstrates entirely the contrary. The fund could have opened and operated these accounts itself, but that was not what was happened. Scion was used instead as an account manager. And so rather than the fund trusting its affairs to the bank, it trusted Scion to deal with these accounts. My learned friend, of course, places heavy emphasis on the change to the designation of the accounts. But there's no suggestion at all that the fund dealt with the bank in relation to that change of name. Indeed, the fund's evidence you were taken to this morning shows very clearly that this arose from discussions between the fund and Scion's directors and administrators, and that Scion then, or through its administrator, Turnstone, Scion then dealt with the bank. So that doesn't do anything more than go towards the allegation that the bank knew that the fund had an interest in the account. But that at most goes towards foreseeability. It doesn't, in my submission, demonstrate anything done by the bank to accept responsibility for protecting the fund's interests. So on that basis, my submission is that the Court of Appeal was right to conclude that without some pleaded basis for an assumption of responsibility, and there is no pleaded basis for an assumption of responsibility, or indeed reliance, the claim was bound to fail.
But the bank knew that the funds were being operated on behalf of, that there were beneficiaries behind the funds, that these were not funds beneficially owned, if you like, by Scion.
That's the assumption, my Lord, yes. That's the pleaded case. We're assuming that for these purposes.
I think you just said, I may have misunderstood what you said.
I may have misspoken, my Lord, but no, it's certainly assumed.
Yeah, thank you.
The allegation that the bank knew of the fund's interest is certainly assumed for these purposes. So that deals with assumption of responsibility. I then move on, if I may, to Royal Brunei and Tan. And of course, Tan is a case about accessory liability for breach of trust. But it nonetheless, in my submission, sets out a line of reasoning from which a close analogy to the present claim can be drawn, and which is wholly inconsistent with the alleged duty that arising on the pleaded facts. And of course, strictly speaking, the question before the Privy Council in Tan was whether the breach of trust, which is a prerequisite to accessory liability, had to be a dishonest and fraudulent breach of trust by the trustee. Yes. And that one sees that at page 921, letter D, for reference. But perhaps the starting point to looking at this case is at 923, letter E, where we see Lord Nichols says that if he's going to resolve the issue that's formally before the court, he has to look more generally at the accessory liability principle.
Just before we get to the dicta, can you just remind us of the bare outline of the facts? What was it the bank, if it was a bank?
It wasn't a bank.
It wasn't a bank, was it?
No.
What was it that the defendant was alleged to have done or not done?
The case was about the sale of a company.
Yeah.
And the defendant was managing director, principal shareholder. And the company had to hold certain monies on trust that it received from the sale until that money was accounted for. And as a result of various wrongdoing, the money was paid away improperly in a way that it shouldn't have been.
And the director was sought to be made liable for not preventing it, presumably.
Well, no, the claim was for accessory liability.
Yes.
For the breach of trust. So yes, in a sense, yes.
Yeah, what was it that he did wrong is my question. Did or omitted to do that was wrong?
The company, essentially, the money was paid, the defendant paid money into its own account.
Yes.
And then rather than accounting to that money, as it should have done, it used it for its own purposes.
Withholding the proceeds of sale to account to somebody else.
Yes.
But instead of
it used it for itself.
Used it for its own purpose.
My lady, yes. And the question, of course, inevitably engaged firstly whether or not the breach of trust had to be dishonest, and secondly, whether or not the breach of trust had to be dishonest, did the third party, who was an accessory, also have to act dishonestly?
So it was a misappropriation of trust money in which the defendant participated with knowledge?
Yes.
Yeah.
And the approach that Lord Nichols takes from 923 letter G onwards is to look at the various possible grounds on which accessory liability could arise. He starts with the possibility there's no such liability, and then considers on 924 the possibility of strict liability and rejects those out of hand, and then turns at 924 letter G to the idea of fault-based liability. And he says, well, if you're having fault-based liability, plainly dishonesty is sufficient fault, but is negligence. And that then, of course, took him into what was then at the time a heated debate as to whether or not negligence was sufficient as basis for founding accessory liability. And he comes back to negligence at page 928, having considered the various authorities and the question of what constitutes dishonesty. Key passages at 928. And Lord Nichols separates the various circumstances in which a claim might arise into two scenarios. The first scenario, at around 928F, is the situation in which someone deals with a third party is accountable to a trustee for their conduct. So he gives the examples of advisors, consultants, banks and agents and so forth. And he says, well, if they act negligently, the trustee can bring a claim against them for breach of trust. And in that context, Lord Nichols says there's no compelling reason why, in addition to the duties owed to the trustees, a duty of care should be owed to the beneficiaries. And we see at G, on 928, it's difficult to identify a compelling reason why, in addition to the duty of skill and care vis-à-vis the trustees, which the third parties have accepted, or which the law has imposed upon them, third parties should also owe a duty of care directly to the beneficiaries. Now, of course, that's a decision in the context of accessory liability, but it is telling in my submission that Lord Nichols is there referring specifically to the notion of a duty of care. That's the language of tort. Similarly, then, at the bottom of 928 and the top of 929, he turns to deal with those who deal with a trustee, but do not owe the trustee a duty of care. And that, again, is plainly a reference to either negligence or contract. And Lord Nichols uses the absence of such a duty to the trustee to justify the absence of any duty to the beneficiaries. And then finally, in the first paragraph at the top of 929, he turns to the second type of case, which is where the trustee is dishonest. And he says at B, the question is whether in this type of situation the third party owes a duty of care to the beneficiaries to, in effect, check that a trustee is not misbehaving. That's a question very similar to the question posed by the duty of care alleged by the fund. And again, that language is language of the tort of negligence when he talks about a duty of care, rather than simply accessory liability. And he says, my only friend suggests that Lord Nichols poses that question but doesn't answer it. My submission, he does answer it, because in the following paragraph, he says the Lordships consider that dishonesty is an essential ingredient here. There may be cases where, in the light of the particular facts, a third party will owe a duty of care to the beneficiaries. As a general proposition, however, the beneficiaries cannot reasonably expect that all the world dealing with their trustees should owe them a duty of care to lest the trustees are behaving dishonestly.
This is all under the general heading at 928E, isn't it? This is about an honest third party who receives no trust property.
Yes, an honest third party who doesn't. So it's not about knowing receipt or.
No, the trust property doesn't come into his hands, even if he's the managing director of the trustee.
Yes, yes, the money doesn't come into his hands. It's only about accessory liability.
What does he have in mind in the second sentence of the paragraph you've drawn our attention to on electronic page 929? There may be cases where, in the light of particular facts, a third party will owe a duty of care to the beneficiary.
Lord, yes, of course. It's clear that the possibility of a duty of care in particular circumstances is not ruled out entirely. And the question of whether or not such liability, whether the facts are sufficient to establish such liability, is obviously a matter for the law of negligence, which Lord Nichols doesn't go into here. But what is, firstly, from the perspective of the law of negligence as I submitted is today, the particular facts in question would be facts that demonstrate an assumption of responsibility by the third party to the beneficiary. And the fund's position that knowledge of the beneficiary's interest in the funds, or even notice of possible fraud, that, in my submission, gets one very close to, if not exactly in the position of establishing as a general proposition that beneficiaries are owed a duty by third parties dealing with the trustee. Because if Millennium Friends' pleaded case were a basis for a duty of care to be established in the form alleged, then in my submission such a duty would arise almost as a general proposition. And that, in my submission, would be inconsistent with what's said here in TAN.
Is there any case which has applied TAN to a situation where the third party is the trustee's bank in which the relevant trust property is held in an account?
I don't know, my lord.
And you can understand why I ask, because
well, I'm sure there have been cases where the bank has been alleged to have been dishonest.
Well, yes, but where the dishonesty or bust principle was applied,
yes,
so that a trustee's bank was exonerated from liability on the ground that it wasn't dishonest, even though it could be said in a sense it was holding the trust property.
In Singularis, there was also a dishonest assistance claim against the bank.
Yes, I mean, yes. I'm not saying there isn't one, but I'm looking to see whether there has been a case which applies the TAN exclusionary principle to that kind of third party.
No, I'm not aware of any case which applies TAN in the context of negligence. Perhaps I can put it that way. There will be lots of cases about dishonesty, obviously.
Yes.
I can't cite a particular one, but I'm not aware of any case where it focuses on the negligence aspect of it.
What's going through my mind is that in that important statement of principle, the board is making it very clear that it's talking about third parties who don't receive any trust property. And I have, as it were, in my mind, Mr. Ald's submission that this was the fund's money and it was held in the bank. They're not making a claim for breach of trust. I appreciate that.
No, and there couldn't be. It wasn't held by the bank on its own behalf. So I don't think there could be a claim against the bank for receipt of trust funds.
No.
Not when it's simply holding them. It's ministerial receipt. in an account on behalf of,
No, no.
of the customer.
No, no.
So in my submission, that wouldn't arise in this scenario.
But the funds in the bank were not funds arising from a breach of duty. They were legitimate funds paid in by the investors, so far as we know. It was the payment out of them that was the problem, not the receipt of them. They were received either from the investors or from the solicitors.
I mean, the receipt issue would come on down the line when the fraudulent assets are received by somebody else.
Yes.
I don't think there's any prospect of the bank being themselves, you know, a constructive trustee because of receipt. But I think Lord Briggs is asking about whether there's a banking case where TAN has been applied.
Yes.
Not that I'm aware of.
Okay.
I mean, perhaps if you find one subsequently, you could let us know.
Yes.
That would be very helpful. Thank you.
I suppose once the Quince Care duty was created, one didn't need to go down that route.
Milady, yes, I'm sure there are more straightforward ways of dealing with the matter. My learned friend, of course, says one can ignore everything that the TAN says because it's in a case about accessory liability, not negligence. But in my submission, that's not right. Firstly, because the language and reasoning used by Lord Nichols demonstrates a clear overlap between the two, and he saw no real reason for policy to differ depending on the cause of action. Secondly, in my submission, the conclusion in TAN is consistent with the law of tort and the circumstances in which a duty of care arises to protect against third-party wrongdoing, or more specifically, the fact that there is no general obligation to protect against third-party wrongdoing. And thirdly, it simply makes no sense in my submission to say that negligence is not enough for accessory liability, but on the same facts, the same loss can, as a general proposition, be recovered through the law of tort. Why, as a matter of principle or policy, should the position differ simply because the claim is brought in negligence rather than for accessory liability for breach of trust? My submission, there's no reason why it should. Nothing in Lord Nichols' reasoning suggests he saw anything in that distinction. So in my submission, TAN points very strongly against the existence of the duty on which the funds claim depends, and in my submission, the Court of Appeal was right to rely on it. That then takes me to White and Jones. And in my submission, it's not at all analogous to the circumstances of this case. Perhaps worth identifying the two separate routes to non-client liability that were identified in White and Jones. And one can see those from page 1010. One sees at the top between letters A and B, just after the passage I think I took you to earlier, Lord Gough says, for reasons I have previously given, the Headley-Byrne principle cannot, in the absence of special circumstances, give rise on ordinary principles to an assumption of responsibility by the testator's solicitor towards an intended beneficiary. Now that, of course, implicitly recognises that there may be special circumstances in which a liability can arise on conventional principles. Indeed, there's no reason why such principles cannot be applied more generally to the liability of a solicitor to a non-client. A duty can be established if it arises on a conventional application of Headley-Byrne principles. Now, the difficulty in White and Jones, of course, was that the conclusion was that in the normal course of events, a duty to an intended beneficiary cannot be established under conventional Headley-Byrne principles. And one sees that at letter C, where Lord Gough says the present case is, if anything, R fortiori, since the nature of the transaction was such that the solicitors were negligent and their negligence did not come to light until after the death of the testator, there would be no remedy for the ensuing loss unless the intended beneficiary could claim. And that really is the lacuna of liability.
That's the Lanester sludge point, isn't it?
Quite. There's a lacuna of liability And that is what leads the court to extend the duty of care that's owed by the solicitor to the client to the intended beneficiary. But it's important to note in my submission that that lacuna is one that is inherent in the nature of the transaction. The fact that there would be no remedy for the breach of duty owed to the client in circumstances where the loss is inevitably only suffered by the intended beneficiary and not by the client. That's inherent in the nature of the arrangement where this is concerned with the making of a will in favour of a beneficiary. The testator, the solicitor's client, is never going to suffer loss if the will mistakenly gives part of the estate to person A rather than person B. It's the beneficiary who is only ever going to suffer a loss. But equally, the beneficiary will not, in normal circumstances, be owed a duty. You can't get home on conventional grounds. Yeah. The loss is always with the person to whom the duty is not owed on that basis. That's the lacuna. And that's not something that is specific to the facts of White and Jones or some particular factual scenario. It's inherent in the nature of a solicitor's dealing with drawing up a will in favour of a beneficiary. I mean, my friend contends that the principles established in White and Jones have been extended by a variety of later authorities in which they which support the duty on which they rely. In my submission, that's not right. Personally, White and Jones, in my submission, supports the bank's submission that this claim cannot succeed on conventional principles, just as the intended beneficiary's claim could not succeed on conventional principles, nor can the funds, in my submission. The difference is, of course, that the lacuna of liability that existed in White and Jones and justified the extension of the law there does not exist in this case, and there's no similar room for an extension of the law here. So turning to the authorities that the fund relies on, the first is Gorham and British Telecommunications.
Just before you move on from that, why exactly is there no lacuna here?
Perhaps I can come back to that point in a moment, my Lord. It's a point
I'm
intending to address.
Sorry.
Perhaps I can
take you on
in a moment. Yeah. Gorham is a case that concerned pension rights and life insurance cover that was designed to cover Mr. Gorham's family in the event of his death. So instead of a will, it was insurance. But it's a straightforward example of an analogous lacuna. And that similarity was recognised by Lord Justice Pill in his judgment. One sees that at 1168, just below letter E, where Lord Justice Pill says, in its structure, the present situation is identical to that in White and Jones. Mr. Gorham intended to create a benefit for his wife and children in the event of his predeceasing them. Under the BT scheme, they would benefit substantially in that event. By the time the breach of duty to Mr. Gorham was discovered, it was, with respect to the sum by way of pension rights entitlement awarded by the judge, too late to remedy the position in the defendant's favour. And then he goes on to consider the position of an inter vivos gift, which was considered by Lord Gough in White and Jones. And at the end of that paragraph, just below the subheading Standard Lives case, he says what Lord Gough regarded as the real reason for concern, namely that the only person who may have a valid claim has suffered no loss, and the only person who has suffered a loss has no claim, did not arise. That is, it didn't arise in the case of an inter vivos gift. It does, however, arise in the present case. So that very clearly puts this case as a lacuna case. The second case, just a different lacuna to the lacuna one sees in White and Jones, but otherwise very similar. The second case that my learned friend relies on is Dean and Allen and Watts. And that, in my submission, is very different. It's not a lacuna case at all. If I could ask you to turn to page 1076. One sees the essence of the facts very helpfully summarised at the top of that page. This case concerned a loan. Mrs. Young was the borrower. She instructed Mr. Dolan, who was her solicitor, to draw up security for the said loan over the flat for the benefit of Mr. Dean. He was the lender. Mrs. Young informed Mr. Dolan that Mr. Dean would not instruct a separate solicitor. Mr. Dean relied on Mr. Dolan to ensure that his loan was effectively secured over the flat. So, in those terms, this is in my submission a case regarding the provision of a service by the solicitor to Mr. Dean and reliance by Mr. Dean on that service being provided properly. And that, in my submission, amounts to a duty that can, a case that can, where a duty can be established on a fairly straightforward application of Headley-Byrne principles. And if one sees how the court approached that particular case, at the bottom of page 1077, paragraph 33, Mr. Justice Lightman, who was sitting in the Court of Appeal, said in a situation such as the present, a solicitor is retained by one party and there is a conflict of interest between the client and the other party to the transaction. The court should be slow to find that the solicitor has assumed a duty of care to the other party to the transaction, for such an assumption is ordinarily improbable. But the special circumstances of a particular case may require a different conclusion to be reached. So again, he's talking about special circumstances, the same term used by Lord Gough in White and Jones. And he then refers to the guidance, the well-known judgment of Lord Justice Neal in BCCI and Price Waterhouse, and sets out a lengthy quote from that. And then, if I could ask you to move down to paragraph 35 on page 1080.
Down to or reading 35?
Sorry, looking at page 1080, paragraph 35, my lord. We see there reference to Phelps and Hillingdon, and that's cited in the proposition that the existence of a contractual duty of care or other duties owed by a professional to his employer or client did not of itself necessarily exclude the existence of a duty of care owed to those with whom he dealt with in the course of his employment or engagement. So the mere fact that the contract doesn't stop there being a duty of care in tort. And then finally at paragraph 36, White and Jones is cited as setting out circumstances in which solicitors can owe a duty of care to a third party. If one then looks at the conclusion that's reached, which one sees at paragraph 40 on page 1083, Mr. Justice Lyman says, in my judgment, by parity of reasoning and in the analogous situation which arose in this case, the law can and should impose a like duty of care on A&W towards Mr. Dean in respect of the provision of an effective security, the benefit of which, to his knowledge, the borrowers wished to confer on Mr. Dean, which was fundamental to the loan transactions. There was necessary foreseeability of damage and the necessary relationship of proximity for the law to impose such a duty of care. It is fair, just and reasonable that such a duty should be imposed. There are no policy reasons inhibiting recognition of the duty. So that makes no reference at all to any notion of lacuna of liability. Simply addresses the conventional basis for finding an assumption of responsibility and a duty of care on conventional grounds. And one sees the other two members of the Court of Appeal adopt a similarly conventional approach. There's a relatively short speech from Lord Justice Sedley, page 1086. Where he says, I agree that the appeal succeeds on the single ground, as Lord Slim puts it in Phelps and London Borough of Hillingdon. The law has imposed on Mr. Dolan a duty of care to Mr. Dean in the particular circumstances of this case. Although in the conventional vocabulary such a duty is said to be assumed by the defendant, it is a peculiar kind of assumption because it is independent of the defendant's will or knowledge. So he relies on assumption of responsibility. And then at page 1092, you have Lord Justice Robert Walker, who, to similar effect, says that there was sufficient identity of interest between Mr. Dean and Mrs. Young. He says, for my part, I do not see this as an extension of White and Jones, but as an example of the sort of exceptional case contemplated by the Vice-Chancellor in Grangelato and Richcliffe.
So this is a sort of imposed assumption of responsibility on somebody who hasn't crossed the line.
Well, no, he
had
crossed the line, my lord, because he was providing a service. He was
yes, but not to the claimant.
Well, the service was the provision of the security. which was, and so the solicitor was arranging the security for the loan, which was self-evidently to benefit the lender. And the lender relied upon the solicitor arranging that security properly. So, in that sense, there is a crossing of the line.
Lord Justice Headley speaks of it's the law which, independently of the volition of the acts, exacts such a duty.
Well, Lord, yes, but that's simply saying this is not like, it's not a contract case where the parties consciously enter into a relationship with one another. The circumstances are such that when one analyses those circumstances, as a matter of law, an assumption of responsibility arises, regardless of whatever subjectively anyone thought at the time. That objective approach is plainly right. But that, in my submission, that's a different point from asking whether or not there was something crossing the line. And there was something crossing the line, which was the provision of the service. And indeed reliance on that service being provided.
What's crossing the line is not kind of dealings between them on a sort of factual nature, but the law imposes that responsibility because of the objective assessment of the facts requires it. Is that?
My lady, yes. Where a service is provided for the benefit of someone, and that party relies on the service, foreseeably relies on that service being properly provided, that, in my submission, is a quite clear crossing of the line through the provision of the service.
So this is like a golden belt case?
Yes. Well, what it isn't is a lacuna case.
No.
But was it essential in that case that the solicitor knew that Mr. Dean had not got his own legal advice?
It was certainly significant, yes. One sees that. And sees that if your ladyship looks at page 1083, at paragraph 41, because there was a brief period in which Mr. Dean did obtain his own legal advice, but only for a short period. And one sees towards the bottom of page 1083, the judge held that the reliance of Mr. Dean on Mr. Dolan continued as previously. It's not as though Mr. Dolan could or did reasonably believe that the reliance upon him had come to an end. So, although Mr. Dean did have a solicitor acting for him very briefly, that didn't change anything of substance as far as his reliance was concerned, and as far as Mr. Dolan's knowledge of that reliance is concerned. One can well imagine that if he'd had a solicitor fully engaged on his own behalf in the usual way, the outcome may well have been different. But then he wouldn't have been relying on the counterparty's solicitor to do the work for him. Finally, in this context, before turning to the question of lacuna, I should just say something about Golden Belt. In some places, quite a lot of emphasis on that decision. But in my submission, one can deal with it quite shortly, because on the facts, it's quite clear the bank was found to have provided a service to a third party that wasn't its customer. And that third party relied on the service being provided properly. And that's really all that case tells us. Simply a conventional application of Headley-Byrne principles. And one sees that, just to perhaps make good that proposition. Page 1132. paragraph 177, Mr. Justice Mayles' conclusion, for all practical purposes, therefore, ensuring that the promissory note was properly executed was a service carried out entirely for the benefit of the certificate holders. They were the funds in that case. And one sees at paragraph 191 on page 1135, one sees there a finding of reasonable reliance by the investors on what the bank did. And at 192, the bank knew of all of those factors. So that, in my submission, is an entirely conventional application of Hedley, Bird and Heller. Doesn't, in my submission, assist in this case at all, where there was no service provided by the bank to the funds and where there's no reliance on the bank at all. That then takes me on to Lord Borough's questions about lacuna, which I said I would come back to. My learned friend says that in all of these cases, duty can be owed to non-clients where, absent such a duty, no claim would lie against the negligent professional. That's not, in my submission, right, because it's not the basis for all of the cases on which my learned friend relies, for the reasons I've just given. But secondly, and more fundamentally, my submission is that lacuna is not simply the fact that a claim cannot be brought in a particular case. A lacuna is more fundamental than that. It's a gap in liability for a breach of duty owed by A to B, which is inherent in the circumstances giving rise to such a breach, because party B will not suffer a loss, but party C will, but would not ordinarily be owed a duty of care. That's the sort of lacuna we saw in White and Jones. In my submission, the inherent nature of that lacuna and the gap in liability is important. One can't say there's a lacuna of liability simply because, in the circumstances of a particular case, party B has not suffered loss or for some other reason cannot claim against party A. It has to be something inherent in the circumstances. And on that basis, there is no lacuna in this case. And the Court of Appeal correctly concluded as much. The real reason for that, of course, is that Sion, the bank's customer, had, if one assumes the pleaded facts, an obvious claim for breach of the conventional contractual quince care duty owed by the bank to its customer. And indeed, the fund has a claim against Sion, again, assuming pleaded facts. Now, my learned friend's answer to that point is to say, well, a claim by Sion would fail, or it might fail, and that's something which needs to be determined at trial. In my submission, that's wrong for a number of reasons. Firstly, as I've just submitted, the mere fact that a claim may fail on a particular set of facts doesn't amount to a lacuna of liability. Secondly, they say there's a lacuna because Sion has suffered no loss, had no real interest in the funds that were lost, therefore couldn't claim to recover them. And that, in my submission, is plainly wrong. It was the legal owner of those funds, and it was in a contractual relationship with the bank. And as trustee, it could plainly sue to recover the funds and to reconstitute the trust funds. And indeed, in normal circumstances, in my submission, the trustee would be the proper claimant. And although there are circumstances, and Lord Nichols referred to those in TAN, there are circumstances where the beneficiary can step in and bring a claim. It does so bringing the trustee's claim as a derivative action with the trustee as defendant, rather than bringing its own claim. Either of those options, directly...
Is that what we refer to as the Vanderput procedure? Where the trustees effectively require the the beneficiaries require the trustee to bring the claim on behalf of the beneficiaries?
I don't think so, my Lord.
No.
I'm afraid I'm not entirely familiar with that.
Sorry.
That proceeding. But no, it's a situation in which it's addressed in Robertson Gill more fully. Indeed, if one goes to page 1355, this was a case in which a claim was brought, as it happens, by the beneficiary of a will, not under White and Jones, because it didn't concern the way the will was drawn up. It concerned the way the estate was administered after death. And the beneficiary brought a claim in his own capacity. That claim ran into difficulties, and he wanted to amend to bring a claim on behalf of the estate. And there were various questions raised as to whether that was possible, not least limitation, and that raised various questions as to the circumstances in which a trustee could bring such a claim, and whether or not the circumstances in which a beneficiary could bring such a claim, and whether or not the trustee had to be a party to it. And one sees at paragraph 22 on page 1355 the fact that the derivative action is brought in the beneficiary's own name on behalf of the estate against the third party. The action is a derivative action in which the beneficiary stands in the place of the administrator and sues in right of the estate, and does not enforce duties owed to him rather than owed to the administrator. So in other words, a beneficiary bringing that sort of claim is not saying to the bank that a duty is owed to the beneficiary. It's saying the contractual duty is owed to SIAM, and the beneficiary steps in to enforce that duty in circumstances in which the trustee doesn't do so.
Why couldn't the fund do that in this case?
In principle, my Lord, on the pleaded facts.
So you think it could or it couldn't?
Well,
On the pleaded facts?
It couldn't now,
Why not?
because it's too late.
Why?
It's time barred.
Oh, I see.
But in principle, it may have been possible to do that if that had been done in time. SIAM could have brought a claim against the bank for the breach of the Quince Care duty. SIAM wouldn't do that for whatever reason. The derivative claim could in principle be brought by the beneficiary.
Who were the shareholders of SIAM? Well, if you don't
I'm
know
not
okay.
sure off the top of my head, I'm afraid, my lady.
Because shareholders can sometimes, minority shareholders can sometimes bring a derivative claim.
Yes, they could
The
step
name
in,
of the company.
bring the company's claim. In short, my Lord, my lady, there are a vast variety of routes that could be taken in which a claim could have been brought.
But the pleadings that were annexed to the pleadings in this case, I think SIAM was a defendant.
It was. That was a claim by the fund against effectively the fraudsters, putting it generically, and as one...
And was SIAM struck off the register during the course of that or after that, or had it already...
I'm told SIAM was struck off in 2016.
Oh, so quite late then.
It's not entirely clear why it was struck off, but there was plainly time for the fund to bring proceedings against SIAM. Other sorts of claims could have been brought. SIAM, no doubt, could have been put into liquidation, and the liquidator could have brought a claim. All sorts of things could have happened. To suggest that there's a lacuna of liability here, because there's no possibility, if the bank has breached its Quince Care duty, of anyone ever seeking recourse for that breach of duty, in my submission, is simply not right.
If they bring a derivative claim, then it's, if the claim is lost, it's the company's assets which pay the costs, or is that then the cost drawn from the company's assets, or does that depend on the...
I don't know, my lady. I don't know what the position is on costs as far as that's concerned.
No, I'm just concerned that, as you say, if the company is put into liquidation, the liquidator then has to decide whether it's a proper use of the company's assets to attempt to recoup the money from the bank under a standard Quince Care claim. But if this exists, that's a different route if the liquidator were to decide not to do that, for whatever reason.
That would be an alternative route. But, my lady, the point is, it must be slightly broader than that. The starting point for this is there's no lacuna because Simon can bring a claim.
Yes, I understand that.
Now, my learned friend's answer to that is not a good answer for these reasons. There are a variety of routes, either through which Simon itself could have claimed, or someone else could have asserted that claim. There may be difficulties on the particular facts of pursuing one or other of those routes, but nonetheless, none of that amounts to a lacuna of liability.
So is your essential submission that when we're talking about lacuna, we're talking about the legal position, not what may have happened as a matter of practicality on particular facts?
Lord,
so long as there are legal rights, then that's sufficient.
My Lord, yes. Because one cannot determine after the event, on the basis of various things that have happened ex post facto, whether or not on particular circumstances a duty of care can be established. That would, in my submission, lack any sort of legal principle at all. The next point that my learned friend...
I mean, the limitation issues are really rather complicated if the fund could bring a derivative action on behalf of Sion. I've just been reading on in Roberts and Gill the consequences and whether they should be permitted to amend go on for pages and pages and pages.
It does, my Lord, and I've not sorted
it out. You say we're just not there because that hasn't been attempted.
Quite. That claim has not been brought. No. That doesn't mean, the fact that claim has not in fact been brought doesn't mean that my learned friend can say there's a lacuna of liability and therefore a duty...
No, I can see you're doing it for... Indeed, you say it answers the lacuna point.
My Lord, yes.
Yeah.
In a White and Jones question, the tort, presumably, is also only complete when the testator dies, because that is when the loss is suffered. Is that right? So the limitation period would run from then rather than from the negligent act. Because if the mistake is spotted before the testator dies, then it can be corrected.
And lady, that must be right, although if the mistake is spotted before the testator dies, but is spotted more than 6 years from when the will is drawn up, one can see that if the client...
Well, then one assumes that the testator was actually happy with how it had been drafted.
Well, it depends on whether or not it's corrected. But in terms of the beneficiary's claim, I suspect your ladyship is probably right that the losses accrues on death on the basis that at any point up to that time,
there's no
the will can be corrected. The learned friend's third point on lacuna is to say Simon's claim, if it had one, would fail on causation grounds because it was under the control of fraudsters. And to that I say, firstly, the fact that Simon was under the control of fraudsters is no reason why the Quince Care claim should fail. One has Singularis as the example of just such a case where, again, it was under the control of fraudsters, but eventually a claim was brought. And the fact that the control of the fraudsters in that case was no bar to the claim succeeding. But more strikingly, though, my own friend's argument in this respect raises a quite startling point. His argument is essentially to say that Siam's claim for breach of the contractual Quince Care duty would fail on causation grounds. Therefore, that claim can't be brought. But his client's claim in tort would succeed on causation grounds. So therefore, essentially what my learned friend is arguing is that the duty of care owed to the fund in tort is somehow wider or more extensive than, and certainly different in its nature from, the contractual duty owed to the customer. That, in my submission, would be a very surprising position indeed. It can't conceivably be right that the bank could be under a wider duty of care in tort than it owed to its customer in contract. And again, I've made the point that even if all of this were right, it wouldn't be, as a matter of law, a lacuna of liability. And then, friends, fourth point is to say Simon can't bring a claim because it no longer exists. But that may be true today, subject always to the possibility of restoring it to the register, as the Court of Appeal thought would be possible. But in any event, it's just an ex post facto happening that can't possibly provide a justification for a duty of care being owed by the bank to the fund. So in my submission, there's no lacuna at all in this case, no justification for extending White and Jones, nor is there any analogous basis on which the duty could be extended on more conventional grounds. I said at the outset I would come back at the end to deal with the facts, and I've obviously left myself very little time to do that, and I don't propose to do so in any detail. But my learned friend's argument essentially is that one can't deal with this as a straightforward point of law. More factual investigation is required, or this is such a novel and complicated point of law that we need to find the facts at trial before we can grapple with it. As to the first of those points, if the Court of Appeal's analysis of the law is correct, as I submit it is, then summary judgment is clearly appropriate because the claim is bound to fail on the pleaded facts. And once you start from the position of assuming the pleaded facts to be true, the limited nature of the facts that underpin the pleaded duty of care mean that there's really no real difficulty in reaching a firm conclusion that the pleaded facts are insufficient for the claim to proceed. And indeed, when one looks at the facts that the fund says ought to be investigated, and this is paragraph 30 of the fund's written case at page 707, and I'm not going to go through it in detail now, but those points really focus on questions of notice of fraud. They don't go to any dealings between the bank and the fund. And of course, once we get into questions of notice and duty and breach of duty and causation, the facts do become more complicated. But the prior question as to whether or not a duty of care is owed at all, in my submission, none of the facts that the appellant is highlighting are at all relevant in the light of the pleaded case. If we're right on the law, then summary judgment is clearly appropriate because the claim is bound to fail. My Lord, unless I can assist further.
No, thank you very much indeed, Mr. Wheeler. Mr. Alton.
I'll deal with my brief with those points that I hope will assist you from my learned friend's submissions. Lord, can I just say one thing about clearly, I'll come back to the pleaded case in a minute, but clearly the pleaded case, as the court can see, was based on Baden, and it reflects the wording Baden, which in turn is very similar to the Quince care duty. And that is the starting point of the pleaded case. And clearly, if Baden is now, after all these years, said to be wrong, or the Privy Council now disapproves it in this judgment, then the position is very different in fairness to the person who pleaded this case. Because at the time it was pleaded, there was a case which provided a duty of this sort, and it was Baden, and that is the duty that's been pleaded. The attack on Baden, if I can put it like that, comes through saying that the Ross and Caunter's decision of Vice-Chancellor Gary was effectively wrongly decided or wrongly based. I don't want to go back in detail over the cases and all, but could I just show you one passage from Ross, which is at page 1411, which my learned friend didn't take you to. We've referred in our written argument to certain other passages in the judgment, and my learned friend, I think, also went to those, which show that it isn't simply based on ands, and therefore can't simply be discarded on that basis.
Sorry, what page?
This is 1411, my Lord, I'm sorry.
Thank you.
And it's the passage at the bottom of that page where he summarises his conclusions you'll see he says, despite the dicta in Robertson and Groom and other cases in that line, there's no longer any rule of solicitor who's negligent in professional work and can be liable only to his client in contract. He may be liable in contract and tort. The basis of the solicitor's liability to others is either an extension of Headley-Byrne or more probably a direct application of the principle of Donoghue. Solicitor instructed by his client to carry out a transaction that will confer a benefit on an identified third party owes a duty of care towards that third party, etc. And you'll see after those 5 numbered paragraphs, it concludes that the plaintiff's claim succeeds in that case. So it isn't, with respect, fair to attack the decision or the judgment on the basis that it's based on ands, and because the principle in and was changed, Ross and Cornters can somehow be said to be wrong.
Well, subparagraph 3 is clear Anne's reasoning, isn't it?
Well, it is similar. I don't dispute that, Lord, but I mean, the principle that's stated in 2 is Headley-Byrne and Donoghue. It was a distinction my learned friend made, and I'm just correcting it or trying to. So that's Ross. And if your lordships then could go quickly to the White case.
I think the point being made against you, though, Mr. Old, is that reading Donoghue and Stevenson is effectively, as understood in context, Anns and Merton.
Oh, yeah.
Yes, well,
When he says more probably a direct application of the principle of Donoghue and Stevenson, that, given all the other cases that were going on at the time, really means Anns and Merton. And when you look at the rest of the paragraphs, it's pure Anns.
but I think my learned friend's point, my lord, was that the appropriate authority to be applying was Headley-Byrne in cases of this sort.
Yes.
And I simply wanted to show your lordship that that's exactly what Vice-Chancellor McGarry was doing in that case. In the judgment in White, my lords, begins at, and my lady, begins at 949. And I just wanted to show you what each of the Court of Appeal said about Ross and Cornters, because it's very straightforward. And there are only 3 or 4 passages to show you. 962 is the first one, which is Sir Donald Norfolk, Vice-Chancellor, as he then was. You'll see he notes under a heading, an open question, that neither, this is at E on that page, paragraph E, neither Caparo or Murphy did the House of Lords expressly or implicitly doubt the correctness of Ross. That's where he starts from. And then going over to 968, I won't take the court to the intervening paragraphs, but he reaches his conclusion at F. In my view, Ross is still good law. Venture to echo Vice-Chancellor's prophecy that wherever the bounds of negligence become finally drawn, they will be wide enough to give an affirmative answer to the liability question. And then in the judgment of Lord Justice Farquharson at 975, at the bottom of that page at H, he also reaches the conclusion that Ross and Cornters was correctly decided, and that a duty of care was owing in the present case by the defendants to the plaintiffs. And then Lord Justice Steyn at 981.
I mean, the slight problem is what you mean by correctly decided. I mean, my understanding of what they're here saying is, if that case came up today on those facts, a duty of care would be decided to be owed. The claimant would succeed. I think the case against you is, but the reasoning would be fundamentally different.
Well, it would be different, and of course I accept that, because the authorities have changed in the meantime. But I mean, and that is a point which both the Court of these judgments in the Court of Appeal in White and indeed the judgment in the House of Lords could have made, and they didn't. And at no stage it said that we're only supporting the conclusion in Ross and Qantas, but not the reasoning. They are, in each case, and indeed if you look at the bottom of 981, Lord Justice Steyn, who spends a good deal of his judgment dealing with this very issue, he says between G and H, I recognise there may be difficult problems to be considered in the future. It does not seem to me that Ross created an uncontrollable principle. In my view, requirements of foreseeability, proximity and justice, which are needed to establish a duty, together with the concepts of breach, causation, loss and remoteness, are adequate to contain the liability in a Ross and Qantas type situation, of a Ross and Qantas type with an acceptable limits. And in my judgment, the recognition of a duty of care in such a case involves special considerations, will not assist arguments on the recoverability, etc.
But, I mean, how much can we really rely on what they say in the Court of Appeal in White and Jones in the light of what Lord Gough says in the House of Lords at page 1009 going over to 10? Robert McGarry must, with great respect, an ordinary action in tortious negligence on the lines proposed by Sir Robert McGarry and Ross and Qantas must, with great respect, regard as inappropriate.
But nevertheless, the decision stands as a result of the House of Lords in White as well, my lord. It's not been overruled. So to say, I mean, my learned friend's argument, anyway, isn't itself about Ross and Qantas. It's about Baden, and I simply draw to the Court's attention the fact that Ross and Qantas is good law. It was considered, it's received, as it were, the glowing recommendations that I've just referred to in the Court of Appeal. And it's not a fair basis or proper basis in my submission for seeking to disapprove of the decision in Baden, because Mr. Justice Peter Gibson applied the law as it then was, according to the House of Lords, in relation to negligence. My second point on all is this. The Court has asked a number of times about narrowing features, if I can call them that, in relation to the duty which we say was owed. And without going back to what I described in my submissions as a pleading point, clearly the more narrowly defined form of the duty which is pleaded in the second of the two, each case, the second respective paragraph, which reflects both Baden and Quinscare, is the duty as a matter of substance, which we say is the duty in this case. And it's a straightforward and in terms of its operation, a practical duty, I would submit, where what the bank has to do is perfectly clear. The only question is, in what circumstances does the bank have to do it, and when does it have to do it? And here there are a number of features of this case which are very unusual. Your Lordships and Ladyship have given examples during the argument in relation, for example, the box example and a trustee example, where the underlying assumption is that the party in the Siam position is a genuine party behaving properly. In fact, here, while technically Siam might indeed have been a trustee, it was no more than an administrative cipher which had no substantive involvement at all. The beneficiary, on the facts of this case, had no oversight at all of the accounts which the bank held. As we have seen, and these are not, if I can call it this, in this way, breach points. There are many, many breach points which we relied on, which you were less impressed with. But in terms of features which focus on the facts of this case and take it away from some sort of broad floodgates principle, these were personal dealings, we say, from the documents we've got, not simply thousands of electronic transactions. There was a close proximate relationship between the people at the bank and the funds belonging to the appellants. And doing the best one can with the documents that I've shown you, it's clear that the bank was involved and did receive a communication on behalf of my clients in relation to changing the name in the account. There can be no doubt about that.
Well, that's what I asked Mr. Wheeler, who Turnstone who Mr. Arthur was acting for, and he said he was acting for Siam.
Yes, well, the structure, my lady, is that Arthur is a Turnstone who are managing Siam. But they're doing it clearly on the documents we have and in terms of the way the scheme was supposed to operate on behalf of the beneficiaries. I mean, they are supposed to be managing the funds and complying administratively with instructions from the investment managers to what to do with the funds. That's their job. So when one talks about matters which might have crossed the line, if you simply take the example that we looked at on the documents in relation to the name change, what happened is that the administrators of the funds in Cayman expressed their concern as to the fact that the bank accounts were held in the name of Siam and not the people who beneficially owned the funds, and insisted that something was done about it. Acting on their instructions, Arthur, effectively for Siam, contacted the bank, had some dealings with the bank's legal department, the result of which was the name was changed very significantly from Siam to indicate not that it was a Siam client account for an unspecified client, but actually to name the appellants in the name of the account. Now, without disclosure, my lady, I can't show exactly what happened between Arthur and the bank. We don't know. All we've got are the documents that you've seen. But on the face of it, the instruction from the appellants to Turnstone clearly crossed the line, and the bank responded to it by doing what the appellants had asked them to do. Namely,
is this reflected in the pleadings somewhere, Mr. Robb?
Well, my lord, it's not put, I accept, in terms that it crossed the line, and we haven't yet, or the pleader hasn't yet reduced the case to a level of particularity that's referred to that documentation. I don't even know the pleader had those documents.
If something crossed the line from the fund to the bank, you would think that the fund would have a copy of it. You don't really need disclosure from the bank for that.
Well, all we have at the moment, lady, are the emails that you've seen. What we simply don't know and can't know is how the bank addressed this important request to recognise the beneficial ownership in the account. Now, we just don't know what the bank and the legal department said before they spoke to Mr. Arthur. But in effect, in relation to that exchange, I would submit Arthur was acting at Siam on behalf of on the instructions of the administrators of the fund in Cayman. That's what he was supposed to be doing, and the bank responded to that and did what they were asked. So, and while it's easy for the bank, without giving any disclosure, to say nothing about it effectively and to put the onus on us to try and show exactly what happened, we can't at the moment. But it's perfectly possible the bank knew very well where the instruction had come from. And indeed, you saw in the other emails we looked at that when the matter was reversed and Mr. Arthur was asking for further information from these various Swiss entities connected with the crooks, he specifically said that he was doing so on the instructions of the bank. So clearly, in that sense, the bank is or appears to have been engaging, and indeed there were communications crossing the line in the other direction from the bank, which were being apparently dealt with and complied with by Mr. Arthur. So, in any event, there are in our submission important narrowing features which actually reduce or would reduce the duty in this case very considerably to something which was very closely focused and compliance with which by the bank would have been very straightforward. My learned friend was asked who owns Siam. The answer is the crooks own Siam. So to the extent that it is seriously being suggested that Siam could ever, in the real world, have taken any sort of proceedings, that is completely unrealistic.
Well, Singularis did.
That's true.
And it was owned by the crooks.
Yeah. But that was a very different situation to this one.
Well, why? It seems to be the same. Why is it different? I mean, the point is that the liquidator was put into Singularis and bought the proceedings, but we don't know why that didn't happen with...
No, my lady, I mean, at this stage, no, I have no idea. But in any event, it's not in going back to the crossing the line point, which I accept the court's been concerned about. The question of crossing the line is not a binary question. It's not, and the court needs to look and will need to look at trial, if this case goes to trial, carefully at the conduct of all those involved to see exactly how these communications took place throughout the dealings. But it's not as simple as simply a direct piece of correspondence. There is one passage which may help in this context, and that's in the case of Williams, which my learned friend referred to, which is a 1496. This is Williams against Natural Health Foods in the House of Lords. Under paragraph 1496, under the heading, the practical application of the extended Hedley-Byrne principle, Lord Steyn, starting just below F, says the touchstone of liability is not the state of mind of the defendant. An objective test means that the primary focus must be on things said or done by the defendant or on his behalf in dealings with the plaintiff. Obviously, the impact of what a defendant says or does must be judged in the light of the relevant contextual scene. Subject to this qualification, the primary focus must be on exchanges, in which term I include statements and conduct, which cross the line between the defendant and the plaintiff. Sometimes an issue arises in a simple bilateral relationship. In the present case, a triangular position is under consideration: the prospective franchisees, the franchisor company, and the director. Such a case, where there is personal liability of the director, is a question, and the internal arrangements between the director and his company cannot be the foundation of a director's personal liability at all. The inquiry must be whether the director or anyone on his behalf conveyed directly or indirectly to the franchisees that the director assumed personal responsibility. And he then gives an example from the Fairline and Adamson. And so we would respectfully submit that similarly in the present case, on a proper analysis of the facts at trial, it may well become perfectly clear that through Sion or Turnstone or Mr. Arthur or whatever, despite the fact that there was never any direct, as far as we know, any direct communication from the funds in Cayman to the bank, there was a considerable transfer of information between the two of them, which give rise to circumstances in which the bank can be said to have assumed responsibility, of which the two examples that I showed you are just one small example. And the example that I think Lord Briggs gave to me of the trustee and the very sensible point that a bank can't know the contents of boxes within the bank, it can't be expected to investigate all the arrangements that its customer had looking for fraud. Well, that's not at all what this is about. The reality here is that the bank, in complying with the duty we allege, is responding to circumstances with which it is presented. The benefit of the arrangement in this case was clearly intended to be for the funds substantively, and not simply for Siam, or not at all for Siam, except in a rather technical sense that it was the account holder. The service was for the funds, the service benefited the funds, and the bank received whatever payment it did in respect of providing that service. And it doesn't, in our submission, involve really an extension at all to say that in circumstances where you're being paid for doing something and where the substantive service has been provided to the beneficiary, not to the cipher company, that the court should, in appropriate circumstances, impose on the bank towards the beneficiary, which is very similar nature to that which it owes its own client. Because, as with the other cases that we've looked at, that there is no real difference in substance between the client, the customer, on the one hand, and the benefiting party on the other. So, I'm turning to the other point, which my lord I wanted to deal with, was the question of whether this was some sort of duty to protect, which, in my submission, it clearly is not. The duty is clearly defined, and it is a duty to act. It's a duty to act when on notice of wrongdoing or apparent wrongdoing. And it's a duty not to make the payments that you would otherwise make until you have made proper inquiries. This is nothing to do with when my learned friend went to the local authority cases. The phrase that was used, duty to act, is in my submission directly applicable in this case. The damage here was caused by what the bank did. That's the simple point. And we haven't, of course, alleged that the bank was involved in Mr. Schools in his fraud, in the sense that it was part of the fraud, as my learned friend said. We did suggest that. But it was part of the fraud in the sense that it was the payments which the bank made on the instructions of Siam, both into the house account and then out of the house account and directly, which facilitated the fraud. So the bank did act, and what the duty requires the bank to do is to take proper care and proper steps before it does so. So, in terms of the overall duty, if the Privy Council believes that Barden is no longer good law, then obviously you will make that decision. But in fairness to the pleading in this case, it's obvious that it was based on the assumption that Barden was good law, and it precisely followed the law.
But Mr. Roll, you've had a long debate in courts below about whether Barden is still good law. If you wish to change the pleading in the light of that discussion, you could have done so. Or sought to do so.
Our case, as my lord knows, is that it remains good law. And we've pinned our flag to that mast, as it were. But if that's wrong, then the court is indeed in it turns to the other factors that we've looked at about assumption of responsibility, proximity, and all the rest. And we say, as is pleaded, that at the end of the day, at the point where in late 2011 and early 2012, the names of the accounts are changed by the bank at our request through Turnstone. and where these accounts are identified as high risk, as we saw in the emails, and where the bank is clearly asking for due diligence materials from those involved, there is a very powerful argument on the facts we would submit that there has been an assumption of responsibility, and that the court should, from that point and not earlier, impose a duty. Lord, I'm conscious of the time.
You've still got 5 minutes if you want it. Well,
I haven't any of them.
well, thank you very much. Well, we're most grateful to the parties, counsel and supporting legal teams for the depth and penetrating analysis in their written and oral cases. We will take time to consider what advice to tender to Her Majesty.